If you invest in enough syndications over enough time, eventually one of them is going to get into real trouble. Not just an underperforming quarter. Real trouble, missed debt payments, covenant violations, conversations with the lender about what happens next. Most passive investors have no idea what their rights are when a deal reaches that stage. They don't know what the GP is required to tell them, what decisions require LP consent, or what options exist before foreclosure. In this video I'm going to walk through what deal distress actually looks like at each stage, what your rights are as an LP, and what questions to ask if you think your deal is heading somewhere serious. First, let me define deal distress. It exists on a spectrum. Stage 1, soft underperformance. The deal is below projections but serviceable. Distributions are reduced or suspended. Debt is being serviced. The GP is managing the situation. Stage 2, covenant violations. The loan has financial covenants, minimum DSCR, minimum occupancy, maximum LTV. If the property's cash flow deteriorates enough, the deal may trip a covenant. This doesn't mean default, but it means the lender is now in the conversation. Stage 3, monetary default. Missed a debt payment. This is a defined default event under the loan documents. The lender now has legal remedies available to them. Stage 4, workout or foreclosure. The GP and lender are in active negotiation, a loan modification, extension, or deed in lieu of foreclosure. Or the lender has moved toward taking the property. Understanding which stage you're in determines what your options are and what the GP is required to do. In stages 1 and 2, you have information rights and limited governance rights. The GP must provide accurate financial reporting per the operating agreement's timeline. If they're not, that's a breach. In stage 2, a covenant violation, most loan agreements give the lender notice and cure rights before escalating. The GP typically has 30 to 60 days to bring the property back into compliance. This is when you should be asking your GP. What covenant was triggered? What is the cure plan? What is the lender's current position? The GP is not required to call you for every covenant conversation, but if they don't disclose a known covenant issue in their next scheduled report, that's a red flag. At stage 3, monetary default, the operating agreement becomes critical. Some OAs require the GP to notify LPs of a monetary default within a specified timeframe. Others don't. Read yours. Regardless of what your OA says, a monetary default is a material event that directly affects your investment. If you find out from a co-investor and not from the GP, that's a significant failure of communication. At this stage, request a call with the GP immediately. Ask for the loan documents or a summary of the default provisions. Ask what the lender has communicated. Ask whether a loan modification or extension is being negotiated. Some monetary defaults are curable. A missed payment with sufficient cash reserves can be brought current. An immediate default event on a stabilized property with strong occupancy can sometimes be negotiated into a short-term forbearance while a refinance is arranged. Others are not curable, because the underlying economics are too far gone. Your rights during active distress. Under most LP operating agreements, you have the right to receive financial reports on schedule. You have the right to call a special meeting if you can muster enough LP consent, typically 25 to 51% of membership interests, depending on the OA. You have the right to vote on specified material decisions, sale, refinancing, capital calls, and in some OAs, GP removal. Read the removal provision before you invest. Some OAs allow LP removal of the GP with a supermajority vote if the GP is in material breach of the OA or has committed fraud or gross negligence. Others require court action. If the deal reaches late-stage distress and the GP is not communicating, not taking protective action, or acting against LP interests, the removal provision is the mechanism. In practice, GP removal is expensive, slow, and complicated. It often happens through settlement rather than clean execution. But knowing the mechanism exists, and knowing whether you have the consent of other LPs, determines your leverage. Let me address capital calls, one of the most misunderstood scenarios in LP distress. A capital call is a request from the GP for additional equity from LPs to address a shortfall. This might be to cure a default, fund a needed capital improvement, or cover operating deficits. Most LP operating agreements include a capital call provision. The provisions vary widely. Some are mandatory. If you don't fund, your ownership percentage is diluted. Some are voluntary. LPs can choose not to fund, with no penalty. In this case, LPs who do fund may receive additional ownership interest as compensation for the additional risk. Some have caps, maximum total capital call as a percentage of original commitment. Before you invest, ask, does this OA include a capital call provision? If so, under what conditions can a capital call be issued? Is it mandatory or voluntary? What's the dilution mechanism? An unexpected mandatory capital call in a distressed deal is one of the most jarring experiences in passive investing. Know whether it's possible before you're in that position. Foreclosure, what actually happens? If the lender forecloses, the lender takes control of the property. The LLC's equity is wiped out. LPs receive nothing, or, in some cases, a residual if the sale price exceeds the debt plus lender fees. In most foreclosure scenarios, LP equity is partially or fully lost. The structure of the debt matters here. Non-recourse debt, common in commercial real estate, means the lender's remedy is limited to the property. The GP and LPs are not personally liable for the deficiency. Recourse debt, less common in institutional multifamily, means the lender can pursue the borrower beyond the property. This typically applies only to the GP and certain guarantors, not to passive LPs. If you've invested in a deal with non-recourse debt, your maximum loss is your invested capital. You will not owe anything beyond what you put in. Recovery scenarios in distress. Not all distressed deals end in foreclosure. There are several scenarios that can produce partial LP recovery. Loan modification, the lender agrees to new terms, extended maturity, reduced rate, interest-only period, in exchange for additional equity, sponsor guarantee, or other concessions. LPs may see delayed but eventual recovery. Discounted payoff, the GP negotiates a payoff of the debt at less than par. Requires bringing in new equity or a new buyer. LPs may receive partial recovery. Sale and distress, the property is sold, at a price below projections, possibly below debt, possibly not. LP recovery depends entirely on what's left after debt payoff. Deed in lieu of foreclosure, the GP deeds the property to the lender voluntarily to avoid foreclosure proceedings. Typically results in full loss of LP equity but avoids litigation. In each scenario, your recovery as an LP depends on the gap between the property's value and the outstanding debt. How to navigate deal distress as an LP, practically. Step 1. Stay informed. Know what stage you're in. Ask the GP directly, are we in covenant compliance? Have we had any lender conversations about the loan? Step 2. Know your OA. Read the default, capital call, and removal provisions before you need them. Know what consent thresholds are required for material decisions. Step 3. Connect with other LPs. You're not the only investor. If the deal is in serious distress, other LPs likely know things you don't. A coordinated LP group has more leverage than any individual investor. Ask the GP if there's an LP committee or communication channel. Step 4. Engage counsel if warranted. A real estate attorney who has handled syndication distress can advise on your rights under the OA, the likelihood of recovery in different scenarios, and whether GP removal is a viable path. This is not an extreme measure, it's the tool you may need. Step 5. Be realistic about recovery. A distressed deal in an adverse market may have a defined ceiling on LP recovery regardless of what the GP does. Understanding realistic recovery scenarios helps you make clear-headed decisions. Here's the summary. Deal distress exists on a spectrum: soft underperformance, covenant violations, monetary default, workout or foreclosure. Know which stage you're in. They have different implications for your rights and options. Your rights include financial reporting per the OA, special meeting consent mechanisms, vote rights on material decisions, and in some cases GP removal for material breach. Capital calls: understand whether your OA allows them and whether they're mandatory or voluntary. Know the dilution mechanism before you invest. Foreclosure: your maximum loss is your invested capital in non-recourse deals. Recovery depends on the gap between property value and debt. Navigate distress by staying informed, knowing your OA, connecting with other LPs, and engaging counsel when warranted. The LP due diligence checklist has a full distress and default section, linked in the description. Subscribe for the next one. We're going to get back to the beginning, specifically, how to think about your first syndication investment and the steps to take before you wire. Thanks.